बाद आप स्टार्ट करना, ठीक है। और इसको फुल स्क्रीन कर लो बेटा, प्रेजेंटेशन को फुल स्क्रीन में।
Good morning to everyone. Today, the topic of my presentation is formation and incorporation of a company under the Companies Act 2013. So, firstly, let us discuss that what actually the company means. A company comes into existence when a group of members coming together, forming an association to exploit the business opportunity by bringing together men, material, and management. So it is written that a company comes into existence when the group of persons come under contact and bring a business idea and to exploit that business opportunity by bringing together the men and material and management. So let's discuss the steps involved in the formation of a company. Promotion, incorporation means registration and raising capitals. These are the three steps by which the company can be formed. So firstly, let us discuss that what is promotion. Promotion business opportunity and taking in any company. What actually is in its convention are known as promoters of a company. These are the people who come forward with the idea. These are called promoters, or they invest capital. The person who conceives an idea is the company promoter. Now I hand over to continue the presentation to Ankit.
So now we discuss the functions of promoter. So now we will discuss the functions of promoter. Identification of business opportunity. Second is feasibility studies. In this, they see that there is technical feasibility, financial stability, and economic stability. And third one is name approval. Fourth one is fixing up signatories to the MOA. Fifth one is appointment of professionals. And sixth one is preparation of necessary documents. So now we discuss incorporation stage. A company is said to be incorporated when it fulfills the formalities of registration and obtains certificate of incorporation. So by submitting the MOA and AOA, that is a memorandum of association and article of association, and a written consent to all the directors. A copy of letter of register approving the name of the company, documentary evidence of payment of registration fees. So now there is need to raise capital. So raising capital, entering onto an agreement with underwriters. So first of all, they have to apply to stock exchange for listing of shares because they have to raise capital. They will issue a prospectus, invite public to subscribe. Third one is allotting shares. That is the final stage. Next is memorandum of association, articles of association, prospectus. There are the three documents. which are need to be prepared. And we have to discuss about memorandum of association.
Memorandum of Association contain the fundamental rules regarding the constitution and the activities of the company. So, what actually is the Memorandum of Association? It contains all the fundamental rules regarding the activities, what the companies have to perform, what actually their business is. It is the charter of the company. It lays down the area of operations. Area of operations mean what are the jurisdiction areas of the company under which it has to perform its operations, regulates the external affairs of the company. Now let's discuss the contents of MOA. The contents of MOA are the name clause, the register office clause, the object clause, the liability clause, and the association clause. Now let's see what is name clause. A company adopts the name, but it should not be identical to the name of the existing company. It is written that the name of every company should be not be identical. It should be different. The name of the company must end with the word limited. So all the persons dealing with the company must know that their liability is limited to the extent of their shares. In case of private limited company, private limited is used at last. So it is written that if we want to form a private limited company, now at the back of the name of the company, the word private limited should be used. And if we want to know the liability of the partners, it is just limited because we have used the word private limited. So the liability of the shareholders is limited to the extent to what they have contributed in the business. Now let's talk about registered office clause. Registered office clause contain location of the registered office, the official address for registration, books and records kept. Object clause, an important, it is very important clause. It must be drafted very carefully. Determines the activity of the company. It determines what kind of activities the company wants to do. Each and very detail of the business to be carried out or must be laid down. Liability clause. Liability of a company is limited to the extent of shares purchased by them. As I have already told that in case of private limited company, the liability of the shareholders is to just the extent of what they have contributed in the business. That is, of what amount they have purchased the shares. This clause contains the notice of liability of members of the company. It is essential for the companies in which the liability of member is limited. In case of company limited by shares, in case of company limited by guarantee.
So now there is capital clause. This clause states that the amount of capital with which company is to be registered means to say they have how much money to start the company, that we can say will be the authorized capital. Okay, this clause should also state the number and face value of shares. Like face value of shares can be 1, 2, or 10, whichever will be suitable, into which the capital of company is divided. So the capital which the company is registered is authorized. So we can say it is authorized capital of company is 1 lakh, 2 lakh, and can be anything. So now we will discuss association clause. This clause states that subscribed declare that they desire to be formed into a company and agree to take the shares stated against their names. Means the persons form the company and they agree in between that they will take the amount of shares in their name to form the company. And also subscribers must sign the memorandum in presence of at least one witness who shall attest the signature. So if we have to do some alteration, there can be alterations in the clauses, like there can be alteration in the name clause, alteration in registered office, but for that special resolution is passed, otherwise there will be no alteration. Oh, and confirmation of regional director when jurisdiction of register of company is changed. And they are saying that directors confirmation is very much necessary when company's offices has to be changed from one place to another, like from one town to another or one village to another village. There can be also alteration of liability clause. Liability of company cannot be increased unless the members agrees. If members does not agree, then in writing, then alteration in liability clause is not possible. Like from unlimited liability, it can be limited by registration. Now it is a very important document of the company, that is AOA, Articles of Association. It contains regulations regarding all the internal affairs of the company. Every company has to prepare its own articles, otherwise there is no meaning of company. It cannot be altered. If alteration has to be done, then again, as we discussed earlier, a special resolution has to be passed, otherwise there is no alteration in article of association.
Now let us discuss that the articles of a company must contain which of the following restrictions. In case of a private limited company, restrict the right to transfer of shares. In the private limited companies, we all know that we cannot transfer the shares to anyone. Limit the number of members to 200. In private limited companies, there is a limit to the number of members we can admit in our company, that is 200. Prohibit any invitation to the public to subscribe for any shares or debentures of the company. In this, we cannot invite capital from public sources through issue of shares and all. Now let us discuss the contents of articles of association. The Articles of Association contains the powers, duties, rights and liability of directors, powers, duties, rights and liability of members, rules for meeting of the company, borrowing power of the company, dividends, voting power of members, forfeiture of share. Forfeiture of share means the cancellation of share if the shareholder fails to pay the subscription money that is demanded by the company. Seal of the company. We all know that the seal of company is the identity that the company uses in its uh, judicial problems and the judicial cases. That is called the seal of the company. Now let us discuss that what is prospectus. Prospectus is a document which invites public to provide funds to the company or subscriptions to its shares or debentures. Now we can correlate it when the company issues its IPO. We can see that in our demat account, we can see it in the details of the company. We are shown the prospectus of the company that we can download, and we can see all the details. The prospectus contain all the details regarding the company, its board of directors, everything that we know if we want to invest in that company. Everything it is written in the prospectus. It is a very valuable document containing all the important details of a company that I have already said. It should be duly signed by the company. Yes, it is very important that the prospectus is duly signed by the company. Now let's discuss the contents of the prospectus. The prospectus contains the name of the company, that I have told that every company should have unique name, and it should not be identical to any other company present in the market. Address of the registered office. It contains the address of the registered office where the headquarters and the other franchises of the company exist. Nature and object of business. What kind of business the company is going through. Capital structure, how it is raising a capital, how much its market capitalization is there, and that all is written in the prospectus. The history of the company, that how much years have been passed since the company is incorporated, outstanding liabilities, that before the issue of shares, how much liability the company is outstanding. Financial information, consent of manager personnel, particulars about the underwriters, auditors, and brokers. Statement in lieu of prospectus. A public company issues this to the register of companies at least 3 days before the allotment of share. Now, when the IPO is released by the company in the market, we all know that we apply for the IPO. It is up to our luck that because it is very random process. One can get the IPO, another cannot get the IPO. So before the allotment of shares, that is on the listing date, exactly 3 days before, the company has public company issues it to the registrar of companies.
So now we have to start incorporation of a company. So first of all, in incorporation of a company, we have to obtain digital signatures. Nowadays, various documents prescribed under the Companies Act 2013 are required to be filled with digital signature of managing director or manager or secretary of the company. Therefore, it is compulsory required to obtain a digital signature certificate from authorized DSC issuing authority for at least one director to sign the e-forms related to the incorporate like form INC1 and other documents. So now, second is to we have to obtain director identification number under section 153. Every individual intending to be appointed as a director of the company shall make an application for allotment of DIN in form DIR 3 to central government in such form and manner and along with such fees as may be prescribed. Therefore, before submitting of e-form INC 1 for availability of name, all the directors of the proposed company must ensure that they are having DIN. And if they are not having DIN, it should be first allotted. This is very compulsory step. So without obtaining DIN, there cannot be formation of or incorporation of the company. So now we have to see this name availability of for proposed company. As per section 4, subsection 4, read with rule 9 of the company's incorporation rules 2014. Application for the reservation availability of name shall be in form number INC1 along with prescribed fees of rupees 1000. In selection of the company name should be in accordance with the name guidelines given in the Rule 8 of Companies Incorporation, Rule 2014. There is note that MCA has prescribed certain rules for name availability, so it is advisable to check guidelines for same before applying for the name. Refer Rule 8 of the Companies Incorporation Rules 2014. After approval of the name, ROC will issue a name availability letter. Approval for availability of name for a proposed company. Validity of name approved by ROC. As per section 4, subsection 5, maximum time for which name will be available has been prescribed in the law itself under section 4, subsection 5. The name will be valid for a period of 60 days from the date on which application for reservation was made. So there is a note again, the applicant cannot start business or enter into an agreement, contract, etc. in the name of proposed company until and unless a certificate of registration is issued by the Register of Companies as per the provisions of Companies Act 2013 and the rules made thereunder.
Now the next step is preparation of memorandum of association and the articles of association. As we have already discussed that what is memorandum of association and articles of association earlier, drafting of the memorandum of association and article of association is generally a step subsequent to the availability of name made by the registrar. It should be noted that the main objectives should match with the objects shown in E-Form INC 1. These two documents are basically the charter and the internal rules and regulations of the company. Therefore, it must be drafted with utmost care and with the advice of the experts, and the other object clause should be drafted in a very broader sense. As per section 4 and subsection 6, the memorandum of a company shall be in respective forms specified in table 1 A, B, C, D, E in schedule 1 as may be applicable to such companies. As per section 5 subsection 6, the articles of a company shall be in respective forms specified in table F, G, H, I and J in schedule 1 as may be applicable to such companies. Now let's discuss the application for incorporation of a private company. In this we will discuss that how we can apply for a private company. So it's basically the rules. So it is mainly a reading portion that I'm going to cover. As per Rule 12 of the Company Rules 2014, application for incorporation of a private and a public company with the registrar within whose jurisdiction the registered office of the company is proposed to be situated shall be filed in form number INC 7, Rule 12 to 18, along with form number INC 22 for situation of registered office of the company, as the case selected in form number INC 7 and DIR 12 with the following attachments. Form number INC 7 attachments are read section 7 of the Companies Act. Memorandum of Association as per table 1 of schedule 1. Article of Association as per table F of schedule 1. This portion contains what the Form 7 INC 7 include. Articles of Association as per Table F of Schedule 1, declaration in form number INC 8 by professionals. Declaration in the prescribed form by an advocate, by a CA, CMA or CS in practice who is engaged in the formation of a company, and by a person named in the articles as a director, manager, or the secretary of a company, that all the requirement of this act and the rules made thereunder in respect of registration and matters precedent or incidental thereto have been complied with.
So now necessary thing is affidavit, which is very important from each of the subscriber to the MOA in form number INC as per Rule 15 of Rules 2014. Because affidavit in has to be subscribers has to tell that if there is any offense have been committed by them or not from the persons named as the first directors, if any in the articles, that he is not confessed any offense, as I said earlier, in connection with promotion, formation, or management of any company, or that has not been found guilty of any fraud or any breach of duty to any company under this act or any previous company law during the preceding 5 years, and that all documents filed with the register of registration of company contain information that is correct, complete and true and best of the knowledge and belief. So मेनली एफिडेविट में यही है कि वो सब कुछ क्लियर करता है कि इसने कोई भी क्राइम नहीं किया और कुछ भी फ्रॉड नहीं किया उसमें डायरेक्टर बनने से पहले, और कोई भी ब्रीच कुछ भी उसने गलत काम नहीं किया. So, proof of residential address, the address for correspondence till its registered office is established, वो एड्रेस का उसको प्रूफ देना पड़ता है. For verification of signature of subscribers pursuant to Rule 16 of Companies Rule 2014 in form number INC 10, एक एनओसी देनी पड़ती है नॉन ऑब्जेक्शनेबल इन केस देयर इज अ चेंज इन प्रमोटर्स फर्स्ट सब्सक्राइबर्स टू एमओए. आइडेंटिटी का प्रूफ देना पड़ता है, जैसे कि उनके फैमिली नेम, सर नेम, एड्रेस, नेशनलिटी क्या है उसकी, एंड सच अदर पर्टिकुलर्स ऑफ वेरियस सब्सक्राइबर्स टू मेमोरेंडम एंड पर्टिकुलर्स ऑफ पर्सन्स मेंशन्ड इन द आर्टिकल्स as the first directors of the company along with the proof of identity as may be prescribed.
कुड़ियां चल पता दी जवाक पढ़ना
वीरपाल माइक ऑफ करो बेटा. वीरपाल स्विच ऑफ योर माइक.
So there is entrenchment articles of association, if any. Note where the article contains the provisions for entrenchment, the company shall give notice to the register of such provisions in form number INC 7 as the company may be, along with the fee as provided in the company's registration of offices and fees, rules 2014, as the time of incorporation of company. And the next is we have to require is PAN card in the case of Indian national, copy of certificate of incorporation of foreign body, corporate, and proof of registered office address. Certified true copy of board resolution consent by all the partners authorizing to subscribe to memorandum of association. Optional attachment, if any, form number DIR 12.
As per Rule 17 of the Companies Rules 2014, the particulars of each person mentioned in the articles as first director of the company and his interest in other firms or bodies corporate along with his consent to act as director of the company shall be filed in form number DIR 12 along with the fee as provided in the company's registration offices and fees rules 2014 along with the above details in the form number INC 7 form number DIR 12 to be filed with the following attachments. Now let's see what are the attachments that are contained in this form. Attachments are declaration by first director in form INC 9 is mandatory to attach in case of a new company. Declaration of appointee director in form DIR 2 interest in other entities of director it is mandatory to attach in case number of entities entered in more than one. Optional attachments. Now let's see what are the optional attachments. Form number INC 22. As per Rule 25 of the Companies Rules 2014, verification of registered office shall be filed in form number INC 22 along with the fee. Section 2, subsection 2 of the company, Section 12, subsection 2 of the Companies Act 2013 states that the company shall furnish to the registrar verification of its registered office within a period of 30 days of its incorporation in such manner as may be prescribed. It is written that according to Companies Act 2013, it is necessary to inform the registrar within a period of 30 days since the incorporation of the company. Section 12, subsection 4 of the Companies Act 2013 state that notice of every change of situation of the registered office verified in the manner prescribed after the date of incorporation of the company shall be given to the registrar within 15 days of change, who shall record the same. In this section it is written that if there is physical change in the location of the company, we shall inform to the registrar of the companies within 15 days. Along with the above details in the form number INC 7, form number DIR 22 to be filed with the following attachments. Now let's see the attachments. Attachments are proof of registered office address, agreement along the rent receipts, etc., or rent agreement in the name of the company along with the copy of rent paid receipts not older than 1 month, or the authorization from the owner or authorized occupant of the premises along with proof of ownership or occupancy authorization to use the premises by the companies at the registered office, and the copies of the utility bills as mentioned above not older than 2 months. The proof of evidence of any utility service like telephone, gas, electricity, etc., depicting the address of the premises in the name of the owner or document, as the case may be, which is not older than 2 months. List of all the companies specifying their CIN having the same registered office address, if any. Optional attachments, if any.
So, purpose of the e-form 7. From the above, we can easily understand that loads of information is to be arranged for incorporation of company under Companies Act 2013. So it is also important to understand the purpose of e-form INC 7, as it is also a very important form. ENC form INC, e-form INC 7 deals with incorporation of a new company other than OPC. This e-form is accompanied by supporting documents such as details of directors, subscribers, the MOA and AOA, and evidence of payment of stamp duty. Once the e-form is processed and found complete, a company is registered and CIN is allotted. Please note the following. User is required to file e-form INC 7 for incorporation of company other than OPC within 60 days from the date of application of reservation of name in e-form INC 1. It is suggested that e-form DIA 12 and e-form INC 22 should be filed together at the time of filing of e-form INC 7 when address of correspondence in address of registered office of the company. In case the address for correspondence is not the address of registered office of the company, user is required to file INC 22 within 30 days of its incorporation. Stamp duty on e-form INC 7, MOA and AOA can be paid electronically through MCA portal, and in such case, submission of physical copies of uploaded e-form INC 7, MOA and AOA, the office of ROC is not required. Payment of stamp duty electronically through MCA portal is mandatory in respect of states which have authorized the central government to collect stamp duty on their behalf. Now, e-stamp duty payment is to be done online through MCA portal for all the states. User is required to scan the photograph of every subscriber with MOA and AOA. So now there is a duty of registrar to scrutinize the documents. Scrutiny is very essential to check whether there is accuracy in the documents. If after filling the requisite forms for incorporation with the register of companies along with the fees, ROC is not satisfied or ROC is satisfied with the contents of the documents filed, ROC will issue the certificate of incorporation in form number INC 11 as directed by Rule 18 of Companies Rules 2014. Declaration at time of commencement of business as per Rule 24 of Companies Incorporation, Rules 2014. The declaration filed by a director shall be in form number INC 21 along with the fee, as the contents of form shall be verified by a company secretary, that is CS in practice, or a CA or CA in practice. Provided that in case of company requiring registration from sector regulators such as RBI, SBI, SEBI, means to say Securities and Exchange Board of India, etc. The approval from such regulators shall be required.
Pursuant to Section 11, subsection 1A of the Companies Act 2013 and Rule number 24 of the Companies Incorporation Rules 2014, declaration prior to the commencement of the business or the exercising borrowing powers in form number INC 21 along the following attachments. The attachments are specimen signature in form INC 10, certificate of registration issued by the RBI only in case of non-banking financial companies from other regulators. This certificate we have to provide only if it is a case of non-banking financial company, and the optional attachments if any. Now let's see the additional information given. As per Rule 16, subsection 1 of the Companies Rules 2014, particulars of every subscriber to be filed with the registrar at the time of incorporation, that are name and addition photograph affixed and scanned with memorandum of association and article of association, father's mother's name if any, nationality, date of birth, place of birth, district and state, educational qualification, occupation, income tax permanent account number, permanent residential address and also present address, email ID of the subscriber, phone number of the subscriber, fax number of the subscriber. It is optional. Explanation. Information related to one and shall be of the individual subscriber and not of the professional engaged in the incorporation of the company. Proof of identity. For Indian nationals. For Indian national, PAN card is mandatory. Voter identity card, passport copy, driving license copy, and unique identification number, that is our Aadhaar card. For foreign nationals and non-resident Indians, passport, residential proof such as bank statement, electricity bill, telephone, mobile bill, provided that the bank statement, electricity bill, telephone or mobile bill shall not be more than 2 months old. Proof of nationality in case of subscriber is a foreign national. If the subscriber is already a director or promoter of a company, the particulars relating to the name of the company, the corporate identity number, whether interested as a director or promoter. The specimen signature and the latest photograph duly verified by the banker or notary shall be in the prescribed form number INC 10. Thank you all.
अंकित, इसको समराइज करेंगे? अंकित,
हेलो।
हाँ जी, इसको समराइज करोगे बेटा?
हाँ जी मैम, इसमें यही बताया है कि जैसे हमें कोई भी कंपनी बनानी है, जैसे पहले पर्सन्स कोई भी 4-5 पर्सन अगर मिलकर डिसाइड करते हैं कि कंपनी बनानी है, उसके लिए सबसे पहले कंपनी का इनकॉर्पोरेशन होना बहुत ज़रूरी है। उसके लिए जो हमने स्टेप्स पढ़े, जैसे कि डायरेक्टर आइडेंटिफिकेशन नंबर लेना पड़ता है, सारा कुछ वो प्रोसेस फॉलो करने पड़ते हैं, डिफरेंट डिफरेंट फॉर्म्स भरने पड़ते हैं। उसके बाद जाके हमें इनकॉर्पोरेशन, उसका नेम, कंपनी का सब कुछ हमें अलॉट होता है, फिर हम जाके कंपनी की फॉर्मेशन कर सकते हैं। और उसमें मेन डॉक्यूमेंट्स जो हमने पढ़े हैं वो है मेमोरेंडम ऑफ एसोसिएशन, आर्टिकल्स ऑफ एसोसिएशन, प्रोस्पेक्टस, और वही सब डॉक्यूमेंट्स के बेस पे हमारी कंपनी होती है। उसके बिना हमारी कंपनी का कोई बेस नहीं बनता। सो यही सब बताया हुआ है। उसके रिलेटेड जो भी फॉर्मेलिटीज़ हैं और जो भी सेक्शंस और सबसेक्शन हमने पढ़े हैं, उसके अकॉर्डिंगली हमें चलना पड़ता है।
ओके, ये एक सेकेंड बेटा, मैं एक बार वो करती हूँ। आई जस्ट स्टॉप द रिकॉर्डिंग।